Okay. So the next part of this then is we've got these harms. Can we sue? What potential available remedies are out there in the absence of specific state regulation or statutes? Obviously, if a state has regulated the field, has already said this commercial activity is verboten in schools, this is permitted but only in such and such ways, if any school district or school personnel run afoul of that, obviously we can sue there. But the question is, outside of those mechanisms on the books, what else can we do? And so I did what any good little plaintiff's lawyer might do. I ran through all the potential causes of action. You know, thought, is there any constitutional law here? No, not much. There's no constitutional right to be free from marketing in your schools, although I could twist some doctrine to get there. Not with the Roberts Court, though. But the question then becomes, okay, what about personal injury? What about tort law? These are harms, and the way we've dealt with harms in the past, especially harms from private actors, is using the tort system, personal injury system. And so, back to my first year law classes, I remember we need to have a duty, we need to have a breach of that duty, we need to have injury, and we need to have causation. Here's the problem. At almost every step of the way, those links can be broken. And let me kind of outline a few of those. We could think about the fact that commercialism schools looks a heck of a lot like tobacco and the way we looked at tobacco companies maybe 30, 40 years ago. The fact that they were causing this harm. And some entrepreneurial lawyers got out there and said, okay, how can we sue tobacco companies under these personal injury doctrines like negligence and such? It's a little trickier here because if we look at, first of all, whether or not schools have a duty, we're not there yet. Because yes, it is possible to make a school have a duty to protect children. In fact, all the time we see that. If there are bullies or harassers out there and the school administration is put on notice, they need to protect children. This is, for those of you who are lawyers, this is under the Gebser type thinking. So a duty can be created on the part of the school. The problem is that duty has not been established with regard to commercial activities in schools at this point. Can we hold teachers responsible? Hold that. I'll get back to it. Breach of that duty. That means that there needs to be knowledge, there needs to be knowledge on the part of schools of this potential harm, but they let that harm occur. Okay, we might be able to get a breach, but again, that requires their having a duty in the first place. Then harm. What's the damage here? Well, we've outlined a few of them. The one that you can get your hands on the most potentially from a legal standpoint is the healthcare harms, childhood obesity specifically. And in fact, there is some nascent litigation out there right now that would go directly after McDonald's itself or the processed and fast foods producers out there in the world, saying that they are the proximate cause of the obesity epidemic. That's not far-fetched anymore. Seemed like it a few years ago, but especially in light of what we've seen with tobacco litigation, that's a possibility. It is a whole different thing, though, to say that somehow schools are responsible for that. Unless and until we can demonstrate that the harm is there, whether it's psychological, physical, whatever, and we can demonstrate causation. And here's where the tough thing is. How do you demonstrate causation here? Well, there's images of marketing everywhere in the world. How do we know it's the ones that came from the school? How do we know that those health harms weren't caused by something else that children are doing? Bottom line, for those who care about this subject, we need to do a lot more research in establishing the harm that comes from marketing to children in a pretty direct way. How that results in psychological, ethical, moral harms, how that results in educational harms, distraction from regular schooling, making their minds mud so that they can't think critically, what have you. We need more and better research in that regard. Then I'm going to hire you as an expert witness and we can think about bringing that case. But for now, it's not that good on its face. Okay, what about public health? Could we make this a lawsuit on behalf of state agencies, county agencies, whomever, saying that this has caused much damage to us in terms of our public health care system? Again, not far-fetched. Look at what the attorney generals did with regard to tobacco. They said this costs states so much money. We could say that the obesity epidemic is costing states so much money and that advertising in schools is part of that. Whether or not you actually get to file a lawsuit almost doesn't matter here because people like attorneys generals collectively have a lot of power. And for some of you who've recently followed the Craigslist example where the attorneys general basically got Craigslist to take down their adult services site because they were facilitating sex trafficking, essentially. Who knows whether or not they could have won a lawsuit? It doesn't matter, but the threat or the specter of that was enough. I view this as a real possibility, having public agents, actors bring these kinds of cases. I'll just touch upon two more very briefly and then talk a little bit about what we propose in the brief. One other one is thinking about holding teachers themselves or administrators themselves responsible. I'm always a little bit loath to do something like this because it does take a village, and rarely is it the fault of one teacher, but occasionally it might be. So one could say we need to analogize to other professions where there is a code of conduct or a code of ethics in place, whether it's my code of conduct or an ethics that I need to live under with regard to conflicts of interest and the like, or perhaps doctors whose Hippocratic oath says, first do no harm, even though that's not exactly what the oath says, but it says something close to that. And we could think about establishing standards of practice for teaching. By the way, this goes way beyond just commercialism. You could think about professional standards of practice for teachers in a whole bunch of different areas that could encompass things like conflicts of interest. You know, whether or not they're bringing materials into the classroom might help them somehow, but in ways that conflict with their students. And then we could use that as a way of demonstrating that teachers had this ethical, professional duty to not have that conflict of interest, but in fact they do. We're not there yet, but I think it's something that should be thought about, especially for those who care about the further professionalization of teaching as a freestanding, self-regulating type institution. Last thing I'll mention, and this is a no-brainer, is in those rare instances where you might actually see wrongdoing for commercial activities, and I'm thinking mostly here about incentives that are essentially kickbacks for providing marketing. And again, this is not far-fetched. Some of you might recall the scandal that we had in some financial aid offices at colleges where they were essentially getting kickbacks for providing certain loan packages from certain loan sourcing companies. This could happen. Well, we can go directly after that. That's not a problem under current criminal law and the like. Same thing with certain kinds of conflict of interest laws if it's egregious enough. Bottom line, the upshot is, though, is that there's not really a lot available that we can get our hands on right now in terms of existing law to bring a freestanding litigation. And if I haven't bored you to tears, I'm about to really put you to sleep at this point, because beyond those technical things that are unavailable to us, we do think, and I do think, that there's a real opportunity to begin to establish things like duties of care and to begin to establish the harms by working through our political bodies, whether they be local school boards, but better yet through state legislators who have plenary power over regulating our schools, obviously. And if we can get legislatures to do things like make a finding of fact, legislative fact, that this activity causes harm to children, that's a big deal, because that starts to give us that handle that we need. In fact, if you read the model legislation we prepared for the brief, we have legislative findings in there that include this stuff causes harm. God, I hope somebody adopts that language, because then we've got something to grab onto. And then, moreover, and more directly, we can begin to enforce the rules that legislatures themselves are implementing. The good news is this has already started. I'm sure in the states that you come from, you can probably point to one or two rules on the books right now that regulate advertising on buses, that regulate the sales of low nutrition foods in schools, that regulate other kinds of commercial activities. And what we did in the brief was basically said, okay, let's give some options to potential regulators out there. And we broke it down into three big categories: mandates, balancing tests or regulatory requirements, and then finally process-based regulations. And just very briefly, the mandates, when we talk about that, is these are the things that thou shalt not do. Thou shalt not have vending machines in schools. Thou shalt not market to kids during certain school hours or something like that. And this is appropriate where it's pretty clear that the harm outweighs any de minimis benefit to doing these kind of commercial activities. And we see this all over the place. California has very strong statutes with regard to fatty and low nutrition foods in schools. And schools, as far as I can tell, are complying. That's great. And I think that this is, again, a direction that can go, and pretty easy with regard to the foods issues. Then balancing tests. So, okay, we want to be a little bit concerned about local conditions and local autonomy and decision making. And maybe they know better for their students than what the state capitol knows. Sacramento doesn't necessarily know what's going on in Yolo County. So maybe we should let school boards decide, but let's give them some parameters for decision making. Let's say, here are the harms that you need to balance against these benefits. Or better yet, there needs to be an affirmative showing that these harms have been minimized to the extent possible before allowing this activity. And we drafted legislation that would enact that. And interestingly enough, there's actually some legislation out there that does do that in a couple of states. And then finally, process-based regulations. Let's get the relevant stakeholders involved, let's get them in a room, and let's let them decide. They can use whatever criteria they want, or they can use the criteria that we've selected. But the important thing is here, we have the relevant people in the room making that decision. And that can be done at a pretty high level, whether it's a committee of teachers, administrators, parent group stakeholders, what have you, making the decision as to whether or not a certain contract is going to be entered into. It can be simply disclosure in public hearings. These decisions need to get made in the sunshine, not behind closed doors, which is a really big deal. Most of these do get made behind closed doors. Or finally, we could bring it down to the individual level and say there has to be disclosure and consent of parents. And we do see this. For instance, in Minnesota, you are unable to use computers in the classroom that have access to external websites unless you get specific permission from parents. And their thinking there is not only the kind of nonsense that can go on the web, but in addition to that, the marketing that goes on directly to kids through computers at schools. So I'm going to leave it at that. Last time we checked, I don't know what happened to this actually, but the legislature in Massachusetts was very interested in using our brief to push a piece of legislation it had. I'm not sure where that went, but our goal is to get out there and push the cookie on this a little bit. So take a look at our brief.